Good morning, everyone. Thanks for joining today. We are going to go and get started in about a minute here. We'll give people just a little bit more time to join, and yeah, we'll get started in like 30 seconds or so. All right, so we're right about at 10:01, so we'll go ahead and get started in the interest of time here. Thanks again for joining. My name is Chase Millay, and I am an attorney here at KO. And today we'll be presenting on artificial intelligence and be providing a regulatory overview and some practical considerations for your organization when you're working with artificial intelligence systems. So I'll let my colleagues introduce themselves. So Chris, you want to go ahead?
Yeah, hi, my name's Chris Ahats. I'm a partner in our commercial group.
And hi, I'm Erin Locker, member of our data privacy and cybersecurity group. Thank you so much for joining us today.
Great, thanks both. And again, my name's Chase. I'm an attorney here in our privacy group. Okay, just a couple housekeeping items for before we get going here. First thing is we will do some Q&A at the end, so you should be able to hover over and see a Q&A button on your screen. Go ahead and if you do have any questions, feel free to type in your questions there, and we will work to answer them at the end of the presentation. If we don't get to those, we'll also look to follow up with you afterwards if we're not able to get to those within the hour, and you can always contact us with any additional questions. We will have our contact information at the end. We are recording this webinar, and we will be making it available afterwards, including the slides. For those attorneys who are on the line, the CLE credit is pending, so that's in the works, and it will be approved and there'll be information for a home study for those. So if you know how that works, then that's that. But that's what we're doing in terms of CLE. And then finally, kind of the last lawyer catch-all is, we're putting in the effort right now to kind of learn all these various laws that are coming down the pike with regard to artificial intelligence, but we're providing this just kind of as a general overview. And so this is not specific legal advice, and would recommend working with your attorney directly for any particular advice. Okay. So let's get into the agenda. So just as a very broad overview, we're going to start with kind of going over, Chris is going to share the various kind of AI systems and regulated entities that are in play when we're talking about these various laws that are coming out of the United States and the European Union. Then I'll go over the activities that you might be thinking about in terms of what would a company be engaged in order to be thinking about these requirements. And finally, Erin's going to kind of boil into the details of what are the key requirements when you're looking to develop or implement an AI system. Following that kind of overview of kind of the broad environment of the regulatory landscape, we'll go into kind of practical consideration. So we'll focus on taking a position at kind of each level in the ecosystem. What are your considerations when you're developing a product or service? What are your considerations when you're incorporating a third party's products? And then finally, Erin's just going to give us an overview of general practical tips whenever we're using artificial intelligence systems. So with that, we'll start with our core concepts, and I'll kick it over to Chris.
Yeah, so let's go to the next slide. So basically we're going to start here with AI systems, and then we're going to talk about what entities are regulated. But first, with regard to the AI systems, I put up 3 examples of AI system-focused laws. Now, these are certainly, it's not an exhaustive list. If you're used to this, there's many other laws, but these are 3 good example laws that we can look at. And you start looking at these definitions and you notice that there are similarities. So if you'll go to the next slide, Chase. And so you'll notice that each of these laws is focused on a machine-based system that infers from its inputs how to generate outputs. So there are these commonalities. There's a little bit of some distinction if you read these next to each other. But first question is, where did this come from? This definition comes from the OECD, from a very similar definition that I'll read It's an AI system, is a machine-based system that for explicit or implicit objectives infers from the input it receives how to generate outputs, and then it goes on. But it's very similar to what we see here. And so so we have these similarities, and so we can start working our kind of wrap our head around what these AI systems are. If you'll go to the next slide, Chase. And then you start seeing similarities. Again, these are example laws in that there are two primary roles that you see in a lot of these laws. Not in all laws, as you see in the third example here, with only a definition for a developer, but you have this developer or provider role. And if you can go to the next slide, and that role is largely it is what it says, is the business or the entity that develops the initial system. And then you have this role that is largely dependent on that role, which is the deployer side. Now, so of course, some providers are also deployers at the same time, and also a deployer can be a provider if it makes a substantial modification. If there's a substantial modification, as you can see, you can move into the kind of the original role of the developer or provider. Go to the next slide. Now, when we're pulling these together, we're looking at both the systems and the regulated entities together, and you can start coming up with a framework where you have inputs, AI systems, and outputs, and then down the line here, you have the different roles of providers or developers, deployers, and also there's going to be end users. Some of these laws refer to the end user, some not. So we can look at the different types of input data, like training data, production data, and the prompts the end user is using. And then we can also look at the output. And so this is our first framework of how to analyze these laws. What are the different roles? And also, what are the different components of these AI systems?
Great, thanks, Chris. And so Chris has kind of helped us to get an understanding of kind of what we're talking about regulating. So we're talking about regulating these AI systems, and we're talking about those various entities that are in the roles of either developing them or deploying them. They're either creating the systems themselves or they're making them available to the end users. And so there's a host of laws coming in the environment here. Largely what we're going to focus on today are a set of laws in 3 states, Colorado, California, and Utah, and then also the European Union, who is kind of taking the lead on a really fulsome regulatory landscape to regulate various components of the use of artificial intelligence. So let's start with Colorado. So we have the Colorado AI Act, first one in the state or in the US, regulating AI. And what it really aims to do is to avoid these kind of critical outcomes that would seriously impact a consumer. And so the first kind of duty is for developers and deployers, so that's both of those types of regulated entities, to avoid reasonably foreseeable algorithmic discrimination. So when we're using these tools, is it going to result in discriminating against an end user based upon their social status or their other identity status? And so Colorado is thinking about how do we, like at the outset, put in those protections to avoid algorithmic discrimination. Next is that if we are interacting with consumers, there's a requirement to disclose the fact that AI is involved in that interaction. And so again, we're thinking about notices to an individual to say, hey, here's a chatbot or here's a tool you're going to be communicating with, and making sure the consumer is aware that they are engaged in that interaction with artificial intelligence. And then the kind of unique element here with Colorado is this idea of a high-risk artificial intelligence system, or as Chris mentioned again, an entity that makes a substantial modification to that system that is a substantial factor in making, and then this is this defined term of consequential decisions. And so basically what Colorado is trying to think about is whenever an entity is going to use AI to make a decision in one of these categories. So, for example, whether a person's going to be admitted to a school, or whether they're going to receive a loan, or whether they're going to receive certain benefits from government. That is the type of things that Colorado is looking at, and there are a host of requirements in terms of what those entities need to do if their system is going to be making consequential decisions. Okay, so now that's Colorado. Moving on to California. Classic California, we have a whole host of laws on regulating AI. So there's 2 slides dedicated to California. The first one is this kind of overarching AI Transparency Act. So that applies to this defined term of covered providers. These are larger providers, whether they have, and it's the kind of threshold is 1 million plus monthly users. And we're going to start to see this term here of generative AI systems. And so that means those systems that are, your ChatGPTs of the world, who are going to be outputting content to you through those outputs. And if you're a covered provider making available generative AI systems, here's the host of kind of requirements you've got to have. So an AI detection tool, collecting feedback from users, limiting personal data, and including a latent disclosure in those AI generated images, and requiring any of those licensees to say that. Basically, again, following that strain of keeping the consumer notified that AI is going to be involved in this process. Another law from California is the Generative AI Training Data Transparency Act, bit of a mouthful there, but this one applies only to developers. As Chris noted, that really is, again, related to generative AI systems, and will have a limited kind of scope in that regard. And it requires those developers to provide documentation on the training data used to prepare to make those systems available. And so we'll go into some more details on that, but suffice to say that there's really just kind of the goal here is to have, again, transparency on not only those outputs, but what was behind the scenes in that model in order to generate those outputs. Okay, and then just touching on California, here we're seeing California really look industry specific. So we've got this one here in particular, this law where related to AI and healthcare services that requires a healthcare facility. So your primary care provider or whomever who's using, again, we're seeing that term generative AI to communicate clinical information with patients. What do we have to do? We have to notify the patient. So we've got to have that disclaimer. And then additionally, in that healthcare space, we've got to have a clear instruction on how the person can say, all right, I don't really want to be talking to an AI tool, a chatbot. How do I talk to a provider? That's what California is thinking about there. And then finally, that last bullet point, we're seeing other kind of industry specific considerations from California in entertainment. So use of likeness requirements and elections. What are we doing with deep fakes and those things? So California, as always, lots of laws coming down and looking at these various industries for how to address. Okay, touching on the last state in the US is Utah. And so again, we're seeing this concept of generative AI. Here's where we have this distinction where generally, if just a regular business that's using generative AI, they've got to clearly and conspicuously disclose if they're asked or prompted rather, whether or not AI was used. But Utah's taken the approach where if you're in a regulated occupation, and so that means basically any occupation regulated, licensed by the state, so that would be lawyers, providers, accountants, they've got to prominently disclose that before the written or oral exchange. So distinction there where requirements on general businesses got to disclose if you're asked or prompted by that consumer. For those regulated occupations in Utah, you've got to provide that notification before the exchange with the individual. Okay, last one for me is to talk about the EU AI Act. And really, I think the take home from the EU is to think about EU's approach as a risk-based approach. So here we have this risk categorization paradigm. And really, there's these 4 categories. The first are unacceptable risk systems, and those are straight up prohibited in the European Union. Those would be things like social scoring and manipulative AI and some other kind of categories where, you just kind of get that yuck factor of like AI being used for those purposes. That's what we're trying to avoid with unacceptable risk. Then we go into high-risk AI systems where we talk about profiling. Okay, Chase like this, that, and the other thing. And those are allowed, but then have a higher set of requirements. Next, we get into limited risk AI systems, or things like chatbots or fakes, those types of things where there's not really a substantial risk of a bad outcome there. And then finally, this category of minimal risk. And that would basically be those behind the scenes things you see, like AI video games or spam filters, where we're using tools like that, but there's really almost no risk that there's going to be a negative outcome. Finally, EU is also thinking about general purpose AI models. And again, even in that category, they're looking to say general purpose AI models have requirements like transparency, providing notice, and those types of things, but then have that carve out where if it's a model with systemic risk, then there's additional requirements. So take home from the EU, risk-based approach, and the more risk, the more requirements for you if you're implementing that type of tool. Okay, I'll hand it over to Erin on key requirements.
Yeah, so I think the takeaway here is there's lots of laws and regulations that may apply to the use of AI. This isn't going to change. More states are going to come online with their own AI laws. Globally, AI is going to be highly regulated. There's also a body of law that has applied to automated processing technologies for years from a personal data and privacy perspective. So there's a pretty broad framework of potential requirements to be aware of. And so sometimes I think it's really helpful for businesses when figuring out what obligations might be to put together kind of a framework. And I listed out some questions here. This is kind of often when my clients come to me and want to ask about what they need to do with respect to AI systems, this is kind of the framework that I follow. And these are the questions that I want to know to help identify which laws actually apply, what the requirements might be. So the first question is always, what role are we playing? Are we building our own model? Are we using a third-party model like a ChatGPT or a Gemini and embedding that into our own products? Generally, there's going to be more requirements applicable to building our own model or even incorporating models into our products and services. That's kind of this developer or provider role. And then the deployer role, which Chris went into a little bit in his slides. And then sometimes we're just using AI in the back, like internally for our own business purposes. Maybe our developers are using AI to help build our products and services. Maybe we want to use AI in our HR practices. So those are kind of the first questions I always like to nail down is what are we actually going to be doing with AI and these other automated technologies? Risk classification, of course, is going to be important across the board. Whether we're deploying, developing, or just using an AI system, is it a high risk system? And the way that we're using it, is it a way that can create risk for individuals or general risks to the environment, to society as a whole? Then I like to walk through what are the inputs and the outputs. So when we're looking at the inputs that are going into the model, what is it? Is it personal data? Is it confidential information? And then also the outputs. What are we getting out of the AI system? And how are we going to be using them? Are we using them for some of these consequential decisions that Chase talked about? And then finally, we always look at jurisdiction and then industry consideration. So obviously, if we've talked a little bit about some of the more highly regulated industries, right? So things such as healthcare, insurance, financial institutions, there's going to be specific requirements in some of those more highly regulated industries. So identifying whether or not we fall within one of those sectors is important. And then also, where will the AI system be deployed? Jurisdictional considerations. And then finally, is personal data in scope, right? So that's kind of going back to the inputs question. And if it is, where is the data? The individuals whose data will be put into the system, where do they reside? So you can go to the next slide. So this is just going to be kind of a brief overview of the key kind of requirements that exist out there. So we're not going to, I would say this list that I'm about to give you is the things that when you're thinking about either developing or deploying an AI system or just using it, these are kind of the key things that I would have in the back of your mind as you're looking at how to do that. The first is assessments. So that's risk assessment. So a lot of the laws will have different requirements based on whether the AI system is a high risk system, minimal risk, medium risk. And those requirements are obviously going to be different based on jurisdiction and role, but I think in general, it's a good idea whether we're developing, deploying, or using an AI system to do a risk assessment around that. NIST has recently come out with an AI risk management framework that I think is actually really helpful. They've been developing this for a while. I think it's going to continue to change as the evolution of AI happens, but that's a really helpful tool that can, I think, when there's so many different legal requirements, going back to a framework like NIST can be a helpful way to kind of set some structure around the risk assessment process. And I like the way that NIST kind of talks about these different risks that could exist. Is it harm to people, harm to an organization, or harm to an ecosystem? And that really gives us an idea of where these types of risks might live from either using or deploying AI. Go to the next one. And then also a lot of the laws, like I said, have specific categories for the types of risk assessments that have to be performed and documented. This is just an example of some things that those laws require. Identifying the risks that we know or those that may be reasonably foreseeable in the future. Risks of algorithmic discrimination is a big one. The transparency measures that we're taking around the AI that we're using. So all of these types of factors can go into the risk assessment that in some cases is required to be performed and documented under law. Go to the next. The next piece is audits. So I think of assessments as kind of like the before process. I think risk assessments can happen throughout the life cycle of developing or using AI. Audits I think of as more reviewing what's already in place. So there are a number of laws that require us to be reviewing kind of the real world application of the AI systems that we're using. So this is kind of the idea of testing and auditing post-deployment. And just as an example, there are very specific requirements under certain laws. For example, in New York City, there's an AI-based law that's been around for a while now around employment practices, which requires both deployers and users of AI systems that will make consequential employment decisions. The AI system that's being used, or it's not just AI, but it's really any automated employment decision-making tool, needs to perform a bias audit. And the law includes a lot of really specific calculations and factors that need to go into that bias audit. So it's just one of these things in the background that needs to be performed in certain cases. So next slide. So we've got assessments and audits, and then the next kind of big category is transparency. So what do companies need to put out there when using artificial intelligence or these other automated processing technologies? And there's kind of three main categories. There's transparency to individuals. So think consumers, people who might be impacted by the use of AI. There's public transparency, things that might need to be posted on a website, for example, about either AI models that are being developed or being used for different purposes. And then there's also transparency requirements from developers or providers, the companies that are making designing the model, creating the model, to the deployers, the companies that are actually using and integrating the model into their own products and services. So we'll start with the transparency to individuals. The first is this idea of a pre-use notice. So a lot of the laws and regulations are focusing on when an individual might be impacted. So when their personal data is being used as an input into an AI model, or when AI is generally being used to communicate with them or otherwise interact with them, there's often this requirement for a pre-use notice is what I'm calling it. And for background, this is not something necessarily new. For example, in California, there's been a bot disclosure law on the books for years now about if you're using, for example, a chat bot that's on your website that's interacting with website visitors, there needs to be some sort of notice to California visitors that they're interacting with a bot or an artificial intelligence entity or, some sort of like a digital assistant, there needs to be some clear notice that the person is interacting with a robot instead of a human. So this isn't a new concept, but it is being carried over into a lot of these AI specific laws. So essentially the idea is when a consumer is interacting with AI, it should be clear to them that is happening. And that's true regardless of whether or not the AI being used is considered high risk, minimal risk, low risk. And then, of course, for some of the high risk systems, there's going to be more notice obligations that may exist. And that's going to, in general, those are going to kind of dovetail often with some of these privacy personal data notices that are required to be provided at the same time. The second type of notice, I'm kind of calling output notices. It's these requirements for certain, when the output is, some of the laws are requiring notices to be provided with the output from the AI system. So Chase mentioned this briefly, but something like a content disclosure that basically says this is AI generated content. We can go to the next one. There's also this adverse decision notice. So again, this is specific to when individuals, there's consequential decisions being made by AI or other automated technologies that impact individuals. There's disclosures around if an adverse decision is made, what needs to be communicated to the individual. And then also under some laws, there's a requirement to tell individuals that they have alternatives to have basically humans make the decision for them instead of an AI model. So just as an example, that New York law that I mentioned that regulates AI and automated technologies in the employment sector, there needs to be a notice to candidates or employees about how they can request an alternative selection process, right? So if there's, let's say, a recruitment service provider offers an AI system that will help select candidates for interviews. That's the type of thing potentially where there may need to be a notice to the candidates that they could have access to an alternative selection process. We can go to the next slide. And a big part of some of these individual notices is the rights that individuals may have if they are being, if decisions are being made about them or they're interacting with an AI system. In general, they're going to have the right to correct information that's being used to make a consequential decision, the right to appeal a decision made by an AI system and request human review. There's a right to access information about how their information is being used within the AI system. You can go to the next. A right to opt out of certain decisions that are made by AI or other automated processing technologies. And then in general, I always just like to flag, anytime we're using there are AI kind of specific rights that are provided under some of these laws, but just a reminder to keep in mind that even, under privacy laws, generally, there's a lot of rights of access to personal information, deletion of personal information. So to the extent that we're putting personal data as an input into an AI model, all of those other rights that kind of exist that we know about still apply on the AI side. And so kind of not to forget that, there's also this other body of individual rights that exist. Next. The next one, like I mentioned, is transparency to the public. Oftentimes, in particular with high-risk AI systems under some of these legal frameworks, there's requirements to provide notice and information about how the AI system works, how risks are managed, how the company is essentially governing their internal AI processes. So that's something to be aware of. And I would say in particular, that's something to be mindful of when working with developing, deploying, using something that's considered a high-risk AI system. Next. And like I said, there's also this transparency requirement from those providers to the deployers. And this is kind of a tool. It's essentially a tool to make sure that the deployers and like the downstream users of AI are able to comply with all of these requirements under the law, and to make sure that the entity that's kind of building the model, putting the model out there, is making this information available to individuals about risk, about methodologies being used, about data governance measures. So in particular, laws like Colorado have a really specific list of information that needs to be provided. So that's good to be aware of if you're developing a model, but also if you're interested in using a third-party model in your own services, you may have the right to access some of that information from the provider. And then also just this idea of an AI governance program. So this is a requirement under a number of laws. And also I think, in general, a good idea to have some sort of governance program in place, whether or not we're developing AI, deploying it, or using it. A lot of the AI governance programs are based on this idea of managing risk within the organization and external risk, how AI use can have an impact outside of the company. There's a requirement for annual comprehensive reviews of AI being provided, deployed, or used. Requirements to appoint authorized or responsible individuals within the organization who are overseeing AI risk management. And just flagging that Colorado in particular references some of these specific industry frameworks that I mentioned. So like the NIST AI risk management framework. And then there's also other frameworks out there, industry frameworks, that can be helpful in establishing a risk management program internally. Okay. Now we'll go back to Chris on some practical considerations.
Yeah. So, so we've hit you with a lot. So we'll take a moment here and kind of take stock of what we have. I mean, so far we have a lot of different different entities, different types of systems, different types of risk. And so now we're getting to the point of how can we tie all of this together? Obviously not all the different roles are created equal, not the different sensitivities of inputs and sensitivities of how you use outputs, and also just the sensitivity of the system itself. And so we're going to start pulling this together, or try to, in a practical way. And so you now have you're going to develop an AI product or service. And so you could be in that developer role. Also, though, remember that the developer role and the deployer role are a bit fluid because you have this concept of making a substantial modification. And so if you're a deployer and you make a substantial modification, that's a different definition under these laws at times. But once you're there, you could find yourself in the developer role. And so these are a bit fluid of concepts, but we're going to look at some of these laws and try to pull out some of the common trends you see, common threads that you see. So we're going to start with what I kind of see as the most limited, the most low risk kind of one of these laws, and low obligations. And so this is the law that Chase had brought up, the AI Gen AI training data transparency law of California. And so what it applies to is developers of generative AI. And you have the definition here of generative AI. And so the takeaway that I would say here is that what does it not apply to? We know it doesn't apply to deployers. We know it doesn't apply to non-generative AI. So it's a very limited law. And so we know here we're kind of in our baseline of what could be required. And we're talking about how do we form a best practice around this? So what is the obligation under this law? And at this kind of, I have developed a generative AI product, probably your most common kind of use case when developing an AI product. And so that first requirement is a transparency requirement that the developer has to post on its website documentation about how it trained that data. So again, in our framework here, looking at it, you have an obligation. This is kind of our entry-level obligation when we're coming to best practices. When we're looking at all those different obligations that Aaron just put forth, not all of them are created equal, but I would say this is your baseline obligation, is that you're going to have when you're working or developing any type of AI, or maybe the most common type of AI, you're going to have a transparency obligation. And so, and this is true even if the developer is not itself a deployer. And so it maybe doesn't interact with end users, but just posting on its website, likely so other developers or the deployers that are using that developer's technology have some insight into that AI, that generative AI system. And so it's a transparency obligation. I would call that your baseline obligation as developers. Chase, you can go to the next slide. And so now and you can just pull up the next slide that shows what it applies to and what you're going to see here. So let me just first apologize up front. Like a lot of what we do as lawyers is we take these large laws and have to just put them on one slide. And so there's a lot of text here. I'll break it down. But here you have, this is the Colorado AI Act. If you were going to summarize it, or if I was going to summarize it in one slide. And so you have here basically an obligation. This was kind of already covered with regard to Colorado and with regard to developers and deployers of high-risk artificial systems. So now we have both obligations on developers, on deployers, and we're dealing with high-risk systems. So what are the takeaways that we can pull from this with regard to, even if you're not deploying a high-risk system in, let's say, Colorado, or you're deploying it only in California. I don't know how that'd be possible, but you're deploying it in another country. But if you're looking for best practices here, one is you have transparency obligations, first and foremost. Now we start looking at those obligations that Aaron was talking about. You have both for developers and deployers, you have both you have external transparency obligations like public disclosures, AI labeling, to the extent it's not transparent. And then you also have what Aaron was describing. It's kind of like AI value chain transparency. So transparency between the developers and the deployers. So here you see the developer has to assist the deployer with regard to creating its impact assessment. And also you have, and as Aaron mentioned, the deployer, or there's consumer disclosures that could also be required. And so these are, again, now you're moving from a system that was low risk and you're looking at just transparency as being your baseline best practice, and you're moving into high risk systems. And now you add additional things like data requirements, technical documentation, cooperation with authorities, reporting to authorities, like the notification that you have to make for if you observe algorithmic discrimination, if you're the developer or the deployer. So these are, I would say, your next level of obligations, kind of best practice obligations once you get into higher risk systems. Now, not up here on the slide, but again, let's look at what's not required. And so what are the things that are not high risk systems? And these are other AI systems such as anti-fraud technology, antivirus, anti-malware, calculators, cybersecurity, databases, data storage things. Generally, technologies that don't interact with people. And you'll see that with the EU AI Act that we're going to go over next. There is an obligation, one very limited obligation, and even in the Colorado Act, for a technology that does interact with an individual, and the obligation is just AI labeling. Now, go to the next slide, Chase. You're going to get a big one. So a lot of text here. I will not go over all this, but now you're in the EU AI Act, and as you've heard, this is generally kind of thought of as the gold standard, or probably the most comprehensive of all the the AI Acts. And so you're going to get a much broader set of technologies that it applies to, and also many additional requirements, even requirements that Aaron didn't go over because they are specific, I would say, to the EU AI Act, like conformity assessments, and registration requirements, or appointing representatives in the EU, authorized representatives. But what you do see here from a commonality perspective, as we kind of build down this best practice, is that for low risk systems, and so we're kind of in the very top left here, minimal risk systems, spam filters, recommender systems, AI-enabled cybersecurity systems. Those are, they just have very minimal requirements, very similar to what you would have under other AI laws, just AI literacy training, kind of like attending this presentation. Then you get into systems, this is kind of our blue category, limited risk. These are systems that do start interacting with people. Chatbots, recommender systems. Here, again, we see the obligation is transparency, informing individuals, marking, like what Aaron was talking about with the chatbot law, prior one of our oldest US, or maybe the oldest AI-focused laws. That one was out of California. And you see transparency measures. Then we get into higher risk systems. And again, we're using this as for best practices, not doing a deep dive on any of these particular systems. And what we see here is these are largely, and this is kind of our, darker purple, you see things that are similar to what we Chase described with regard to the risks that of the high risk systems that the Colorado AI Act is focused on. And here are, and you can read them for yourself, but these are making important decisions about your whether you can get credit, whether you can get education, access to education, victim of a crime status, those types of higher risk systems. And then you move beyond that into basically unknown things that can happen to you that will like monitoring or evaluating you as a criminal, but things that will happen to you outside of any interaction. Biometric monitoring, and also monitoring and things in sensitive protected spaces, like in a university or in the employment context or in public spaces. And so those are deemed, and I believe this is the only AI law that I know of that have a category of unacceptable risks, that you just can't use them. And these requirements go into effect in February, but these are just completely prohibited, highest risk of penalties under the EU AI Act. I believe that's unique, but kind of going back in, how does the different risks that we have here, what can we draw from this? And so then we start looking at the requirements. And here's where actually I want to, the question we always get at this point is, how does generative AI fit in? And so how generative AI in the EU fits within this, what's called a general purpose AI model, and then Chase even mentioned this, and then general purpose AI models that have systemic risk. And if you look at the obligations, which we will in a sec, what you'll find is those obligations, what it requires, are largely a subset of what's in the limited risk. It's really it's all the things that are in the limited risk and some of the high risk systems. And so let's go down there now, Chase, if you don't mind. Thank you. And so basically we just like dived between the line, I don't know, like conceptually. And so we're in this kind of middle area. And so you can start seeing and how these general, as Aaron had mentioned, the integration of, like general purpose AI models, how they fit into AI systems. So a lot of, you could access ChatGPT yourself as just its own model, but it also can be built into a separate AI system, a different, a chatbot or recommender system. And so you have to look at this as another layer with models fitting into systems, as how the EU AI Act. But so here, again, you have different risk categories. And I put them here, but you can start seeing that larger models, or models that can have a larger impact on basic freedoms and economic security, those have additional obligations. And so again, if we're kind of pulling out best practices, we start with the most limited models having AI literacy and transparency obligations, and different types of transparency obligations, and Aaron went over a bunch of them. But then you start adding in, for our gen purpose AI models, you add in data requirements, technical documentation, cooperation with authorities, risk management, and reporting to authorities. Those are similar. All these things that we're looking at here in the requires are things that are largely required under the Colorado AI when dealing with high risk systems. And so you start seeing these similarities, and you can start pulling things out as you move down the risk categories. Can you go back up one, Chase? And then you add on top of that, the things that you add on top are just things like different record keeping, appointing an authorized representative, registrations, different quality management, mandatory logs, conformity assessments, all these additional requirements when you get into higher and higher risk systems. And so these are basically, when we have deployers that come to us, we're looking at where can we pull different best practices from these various laws and basically start coming up with an AI compliance program. Chase, I'll hand it to you.
Great, thanks, Chris. And I see we're at about 10:45 here Mountain Time, so I know this is a ton of information, and we'll keep moving here. And again, please feel free to put your questions in the chat or in the Q&A tool, and if we can get to them at the end, we will. And if not, we'll certainly follow up with you after. Okay, so that's a lot of information coming your way about all the kind of, what the environment looks like, what does the ecosystem look like. Chris kind of started to outline, okay, what are we thinking about if we're actually going to be in that role of a developer or a deployer? What are we thinking about in terms of, all those requirements in the US and in the EU with respect to our various risk categorizations and the like. A lot of complexity there. What I'm hoping to do here in kind of this set here is think kind of broadly about, what if we want to integrate an AI tool into one of our products or services? What if we don't want to start coding out a whole new AI model or doing anything along those lines? We want to have a chatbot, and we want to have which maybe we would be a deployer in those things, but really thinking high level about from a general commercial contracting standpoint, what should we be thinking about if we want to integrate a third party's tool into our products? So the first thing to think about is really just technical compatibility and integration, right? You're seeing all these things here, like, oh yeah, deployers, and there seems to be like, oh well, a general purpose AI is general purpose AI, and maybe one with systemic risk adds that. But what is that tool built on? What is the coding language? Is it able to communicate using APIs? Is it able to scale? What is the actual background of that tool? And so being thoughtful, working with your technology teams to think through, how do we actually integrate this with our tool? What does that look like is going to be critical. So it's great to have these flashy concepts, and OpenAI and these others are probably, sharing all the time, oh, we can help you improve your business. All right, how do we actually integrate that is going to be a key thing to figure out. Next is always, right, we're the lawyers, we're always saying who owns it. So this question of intellectual property, are you going to be licensing a tool? Are you going to be purchasing a tool? And that's around that software that you may be purchasing or licensing. But then in addition to that, who owns those inputs and outputs? Does the provider of that system own those inputs? If the end user is involved, do we need to get a license to the end user to be able to use outputs from the provider? And so thinking about that complex chain of the fact that these models are built on data coming in with certain requirements, the systems are then developed by these developers with their certain licensing requirements. How do we then need to manage that as we sit in between those developers and the end users on the back end? Next consideration is data privacy and security. As Aaron mentioned, right, this is a new permutation of using personal data potentially when we're talking about AI. But in any event, we're still talking about personal data. So all of those laws that we're already becoming more and more familiar with, like the CCPA or the EU GDPR, those are still going to be applicable if we're using personal data in our AI system. So not just thinking about all those that big chart that Chris was showing us with the various categories of requirements based upon the risk level, but if any of those involve personal data, we still have to comply with all those personal data protection laws. And so thinking about, is this going to be responsible, are we going to be processing that information? And if so, where do those responsibilities lie? If we're licensing a tool and the data is going to be going to our third-party service provider, what are their obligations if one of our end users asks us for, as Aaron mentioned, a right of access or a right to delete their information? How do we actually work that out? And so we'd want to be thinking about making sure our documentation, our contracts with those developers, with that third-party provider, accurately or satisfactorily is able to address those compliance requirements we have with respect to personal data. Okay, next is really, I think this is a big one for me, especially as we're in this evolving space and any kind of new technology, is who are these people we're purchasing our third-party product from? Great, flashy new system. It's going to tell us that we can do all these cool new things, but are they going to be around in a year if we integrate this into our processes and then they collapse because they can't get funding to stay alive. Now we just have this kind of broken tool attached to our system and we integrate it all around it. So being thoughtful around, is our vendor reliable? Can they adhere to service level agreements? And really fundamentally, are they committed to providing this product that we're integrating for the long term or as long as we need it in order to continue to provide the product that we're deploying? Next is just the basics. This is where we get into the easy stuff for us lawyers, is thinking about those contractual consideration. Who's going to be on the hook here? What happens if, if there is a data breach, or if if let's say our third party provider violates another third party's intellectual property rights? Maybe they took a software patent or some other software copyright. Who's going to be on the hook if that's the case and we get sued? So thinking about indemnification, requiring them to defend us in the event of a third-party claim alleging, for example, copyright infringement. Do we have adequate insurance around both, not only that we're asking our vendor to maintain insurance, maybe they've got cyber insurance, maybe they've got technology E&O insurance, but do we also then have insurance on the back end? So if there is some sort of breach or something along those lines, it doesn't sink the whole ship. And one consideration, right, like again, going back to personal data, is just thinking about how we address personal data generally and making sure that we're being especially thoughtful around breaches relating to personal data, in particular considerations around, should there be no limits to those liabilities on that vendor if there is a data breach? And then finally, I think, it's just kind of general question of like ethical considerations, right? Like, to me, there's all these legal constraints and all these other components, but I always think about the political fallout. We don't want to have an issue where we have to now go to explain to a bunch of customers or end users, even if we're not legally liable, that, there was some bias or there was some really negative impact and something happened like that. And so what are the steps we're taking to kind of get in front of those problems? And so I think that really comes down to thinking through, do we have certain standards or guidelines for our team to review when we say, all right, if we're going to be implementing an AI tool, what are we thinking about to avoid these things? Yes, the legal components, algorithmic discrimination, which we've mentioned a couple times, but then these other kind of more other things that just kind of have the gross feeling and we just don't want our customers have to deal with, regardless of whether or not we're going to have legal liability. And so, I think those are just kind of important considerations that kind of really just frame the way we're thinking about this generally. Okay, Erin, 8 minutes.
Great, thanks, Chase. Yeah, so this last section is just practical considerations around using AI. So these are some of the things that when I have clients come to me and say, we want to use this new service internally, or we want to, this vendor is going to offer us this AI feature, is that okay? These are just some considerations that come up around actually using AI instead of, right? So Chase and Chris were talking more about deploying or pushing out AI products and services. So there's three key items: IP considerations, privacy and confidentiality considerations, and then the third is this idea of when is our consequential decisions being made with the AI tools we're using. The first, IP risks. This is a really common one. A lot of the time, in my experience, when I see AI being used internally, it's like with developers using AI to write code, or using it for marketing materials, or just using AI generally to produce content. But typically, as a company, we'd want to own the intellectual property of whatever our employees and contractors are creating for us. So just that's kind of the first set of considerations I always suggest looking at is, when we're using these AI tools, who owns the outputs? Do we have a license to the outputs? When, a lot of the times when I'm having these conversations, I'm having it with companies that ultimately want to sell their business or to have some sort of exit at the end. And I always say, if you're sitting there with a potential purchaser and the purchaser is asking you to show that you have, full intellectual property rights in your SaaS platform or whatever technology you've built, if there is AI generated code in that platform, can you do that? So those types of considerations are really important. We also got a question in the chat about like the idea of using AI for putting content on a website, like what kind of disclosures need to go along with that. I will say for purposes of just kind of producing content and code and marketing materials and other, presentations, what have you. A lot of the disclosures and the transparency obligations that I mentioned earlier, those are more about disclosures that are required for the actual technology and the AI model, right? Not necessarily disclosures that need to be used by the end user who's actually using those AI models to generate output. So I think kind of the bigger thing to be thinking about when using AI for something like marketing materials or website content is, do we own it? Do we have the right to use this? Do we have the license from the third-party tool we're using to generate the content so that we can display and perform it on our website? So some potential steps to help address IP risks are things like internal policies and procedures, an AI acceptable use policy, AI governance policy, ensuring that there's review of new AI tools when they're being used by employees. Technical controls with existing vendors. Chase mentioned this even just when integrating AI systems into our products and services. We always want, one, our contracts to say the right thing, and two, something that I see even just when I'm doing this at our firm, for example, making sure that there's like our existing vendors have technical controls in place that don't just mean they're turning on AI features automatically. Ideally, there's some sort of opt-in that has to happen, or there's some sort of admin setting to help control when AI is being used. And finally, employee training. So the next piece is privacy and confidentiality considerations. It's similar here. It's what inputs are we putting in there? Is it personal data? Is it confidential information? How is data being used by the AI provider that we're putting into it? And similar to IP concerns, I think we can handle a lot of the confidentiality and privacy concerns through things like policies and procedures, controls, contract protections, employee training. But just something else to be aware of is, when we're using these AI tools for personal data, that may mean updating things like our data maps and our records of processing activities that we're maintaining under privacy laws. The use of artificial intelligence to process personal data may need to be disclosed in website privacy policies generally, aside from all of the other disclosure and transparency requirements that exist in AI laws. So just being aware of what data is going in and what the implications of that might be under our existing legal frameworks. And then finally, the biggie. Are we using AI internally to make consequential decisions or decisions that have a legal impact on an individual? So this is something that's been regulated under privacy laws for a long time. I mentioned it kind of when I was talking about general requirements in my prior overview. But a lot of these laws are really focused on when AI is essentially stepping into the shoes of a human and making an important decision about another human. So the laws all define what these consequential or important like legal decisions are, but it's things like healthcare services, access to essential goods or services, financial considerations, education or employment. And we can go to the next one. For most of businesses out there, if you're not in a highly regulated industry, the common denominator here is going to be your employment practices. I see a lot of HR service providers integrating AI and other automated technologies into their service offerings. And that's where a lot of companies, regardless of what industry they're in, are going to see these higher risks from using AI in the HR context. So you can go to the next slide. So what I always suggest here is just making sure kind of that there's some audit of HR tools that are being used, and whether any, for example, sorting through resumes, is that using, like, are we using a service that might push the best and the top resumes to us, and those are the only individuals that we're going to interview? Are we using any interviewing, like video interviewing technologies that use AI to help process video interviews? Are we using AI or other automated technologies to make employment decisions? These are all the types of things that should be reviewed much more carefully. And that's where we're going to have things like notice requirements, bias audit requirements. So some of the much more stricter requirements under some of these AI laws. So that's kind of the last. We can go to the end. So that's, we took up a lot of your time. I know that was a lot of information. We are all available for questions. We've kind of run out of time for any more questions here at the end, but please feel free to reach out to any of us. We really appreciate everyone taking the time to be here. These are really complicated legal frameworks that are coming online, and we're here to help you with that. If you just want to reach out to chat about AI, if you have specific questions, we're here for that. So thanks for taking the time, and we will get back to everyone about CLE credit as that is approved. And any other housekeeping items that I'm missing from anyone?
I think just to say, we'll also be sharing the copy of the presentation as well. So that'll be available.
Thanks so much, everyone.
Thanks
Thank you all.
all.